And I'll ask you to introduce yourself and go ahead and get started.
Sure thing. So, well, thank you everyone for one attending and for inviting me to present again. I think as I was, saving the file, this is the fourth or fifth year that I've done some or a presentation with this group, either Kim's group or Shirley's group as well. And I appreciate the opportunity, to get up and to present on numerous topics. I know tomorrow we're going to be covering some stuff related to cost collection and then a little bit on recruitment and retention. But my name is Scott Moore. I am a longtime EMS person, just had my 32nd anniversary this past September 20th. For the last 19 years, I have been a lawyer, an employment and HR-based lawyer, as well as certified by both of the certifying agencies that certify HR professionals in the country. I really, for the last 7 years, have been out on my own. Prior to 7 years ago, had run ambulance services in various types or roles, be it CEO or HR or revenue cycle folks. But in addition to that, for roughly 16 years, I was a call firefighter in my small community of roughly 6,000 people. A service that did, somewhere in the area of around 400 to 500 ambulance transports a year. And like many of you, dealing with some of the same issues that our town dealt with people, and a lack of available staff to respond. So, again, thanks to the RETAC, thanks to Kim and the group for inviting me to come back. So, just the plan for today is to hopefully hit just a little bit on volunteerism that's going on from a statistics perspective, to talk a little bit about the current situation as it relates to volunteers in this country, as well as talk a little bit about what makes someone an employee versus what makes someone a volunteer, just so that we can get some of the technical stuff out of the way. And then we're going to really cover what the latest rules are. And just so we're clear, just like any lawyer, and what frustrates a lot of folks when it comes down to talking with lawyers there are always so many conditioned precedents on some of the things that we say, or our common answer usually starts with depends. And the reason for that is that and this is no exception, by the way, this topic here, when dealing with issues such as things like what makes someone a volunteer versus what makes them a paid employee, even the Department of Labor and the decisions and or advisory opinions that they put out and some of the regulations that they put out really have been very clear that it is a fact specific, that the analysis needs to be done in each instance at each organization, and that there really aren't any super bright line rules. But to the extent that I can give you those, I want to try and do that today. So we're going to talk a little bit about what are some of the rules around volunteers and any payments that you might make for them. And then, a little bit about permissible practices for agencies that utilize or organizations. And this, by the way, when you search for this stuff, of course, there's all different types of volunteer agencies. We're really only concerned with those that are public safety and or EMS based volunteer agencies. So, it won't surprise you to know that volunteerism was on a substantial rise. And in fact, actually, nationally, volunteerism has been on a rise for many, many years. The downside is, we haven't really seen that on the EMS side of things. So volunteer rate in the US is, 30.3% up pretty significantly. Now, a lot of this information was pre-pandemic, because a lot of the details that we've gotten, or a lot of the research that's available right now, has not yet necessarily reflected what's occurred as a result of the pandemic. So, it sort of feels like we have almost pressed pause for the last couple of years. The average time spent volunteering, while volunteerism is up, the average number of hours that people have to volunteer have gone down. And I've seen this in my community. In our call fire department, when I was a kid working at the grocery store, it was okay if the tone went off and folks ran out of their job to go volunteer for the ambulance or for the fire department. Most of the businesses in that community were very supportive of that, because they were sort of neighbors helping neighbors. But what we have seen more recently, as things have evolved and as business has evolved, is that we're really seeing that most businesses are less tolerant of losing people. So, it's not as easy to show up at work after you've been at a fire or been at an EMS call all night, and your bosses are not as necessarily understanding because there are fewer and fewer sort of home or county-based or town-based businesses. So 65% of organizations are operating at reduced resources. Now, what I will tell you is, and we'll talk about this in a minute, my software company that is a separate entity from my consulting work has sponsored for the second year in a row the AAA's turnover survey. And so the turnover survey just got completed. And so we should be putting that information out from the American Ambulance Association soon, but it won't surprise you at all to know that the turnover rates have gone up since last year. Last year, they actually had stayed pretty low, or relatively unchanged. This past year, they went up. They were in years past somewhere in the 20 to 30% range. We've seen the turnover rates go from 20 to 30% to 20 to 36%. So it has increased. So what's happening in the picture behind me on the wall is this picture here, a New Yorker article that came out back in 2019. So just prior to the pandemic, had really talked about the fact that rural ambulance services around this country are really struggling because there are fewer and fewer people who are able to drop what they're doing and go out and answer ambulance calls. In addition to that, especially since the pandemic, we are finding fewer and fewer people who are willing to put themselves and frankly their families at risk to go out and volunteer for their ambulance organization. So changing economies, changing type of community structures, changing workplace. I think there are a whole host of reasons why we're seeing it. And again, we've seen a bunch of ambulance services close over the last, really over the last 4 to 5 years. We've seen a fair number of them close, and or what we've really heard, and I was with Matt Strieger, who I know is no stranger to this group, Matt Strieger last week, and he says that a fair number of his clients are volunteer agencies in the New Jersey area who are starting to transition over to starting to pay their volunteers because of the lack of workforce. Now, one of the things that AAA study did turn out this year, we hadn't measured this in years past, but one of the things that we asked respondents to the survey to answer was to tell us what the percentage of open spots they had. In other words, we didn't really understand. In the past, we knew what turnover was, or we were getting a sense on what turnover was, but we didn't really understand what the open positions or the percentage of open positions for these agencies were. And one of the numbers that really astounded me was that, part-time EMTs and part-time paramedics were, I believe the EMT rate of vacancy was around 33 or 35%, but the part-time paramedic vacancy rate was 55%. That to me sort of, was not incredibly surprising, but that just means essentially they have half as many people as they need in a part-time paramedic rate than what they currently have. So just for the technicalities parts to get through sort of what makes someone an employee versus what makes them a volunteer. So under the Fair Labor Standards Act and under the United States Department of Labor, and just by the way, if anybody has any comments or questions, I encourage you to either plug it into the chat, or you certainly are welcome to just open your mic and interrupt. I don't have any problem. I can't, because I'm in presentation mode. You guys are about maybe 2 inches by 1 inch, so I'm not likely to see you. So if you want to speak up, please just go ahead and speak up. So just under the law, the way the law is, to employ means to suffer or permit to work. For an employer, employers must be paid at least minimum wage, not only at the federal level, but then at the state level. And for anybody who works over 40 hours per week, they have to be paid overtime. And that is in contrast to certainly someone who's a volunteer. And that is an individual who performs hours of service for a public agency, a civic, charitable, or humanitarian, right? It has to be a nonprofit organization, just so we're clear, without the expectation of any compensation for those services. So, right, anyone who is doing that work and not anticipating or expecting to be paid for that work is considered a volunteer. You can, as I said, only volunteer for nonprofit or governmental or civic organizations such as a church. You can volunteer for a municipal organization or nonprofits, but it is not permissible for an individual to volunteer for a for-profit entity. I know most of the folks in the RETAC, in fact, all of them are not, as I understand it, not for-profit organizations. But just so we're clear, people who work for a for-profit organization can never, ever volunteer. You cannot volunteer for the same agency with which that you get paid to work. So Asbel and I were in Texas 2 years ago doing a presentation, and somebody said, geez, I have employees who during the day, we run 3 trucks during the day and 1 truck at night. And he said, during the day, I have employees who work and I pay them during the day, but then at night they volunteer to cover the ambulance. And Asbel kindly did an Asbel, I'm going to stop you right there and tell you to talk to that guy. You cannot volunteer, let's say, and we're going to talk a little bit about what that means, but you cannot, if you are an EMT or a paramedic for volunteering for an organization, if you get paid normally, you can't also volunteer. So I can't get paid during the day and then come back and volunteer doing the same thing at night. That's just not permissible. All right. And I don't know, I can't tell, as again, I don't know if you guys have a sense of, are there volunteer agencies here who utilize both volunteer and paid staff? I don't know if Kim, you can represent for the group.
Yes.
Yes, there are. Okay, so just a quick, we are city employees. Can a dispatcher run as a volunteer fire EMT? Both get paid from city funds. That one we're going to talk about in a minute. And it's going to, again, this typical lawyer answer. It's the reason, the difference between a catfish and a lawyer. One's a bottom feeding scum sucker and the other one is a fish. And so what I'll answer that in just a couple minutes, I think, but it may require, by the way, what I'll say to anybody is some of these answers may require that you and I jump on the phone and have a separate conversation, because it comes down to what duties and obligations, but hopefully I'll answer that question as we move along. So Colorado state law, really touches on, and you guys may know this as well as I do, but it really generally those people who are performing volunteer, that activity has to be generally part-time. It has to be the kind of work that is typically associated with volunteer work rather than with paid work. Services that are offered free and without coercion. So in other words, we haven't indentured anybody to do this kind of work. We haven't sort of pressured them into volunteering their time. Oh yeah, you really should come back. Everybody else is giving up their time, so should you. You kind of can't do that sort of stuff. And the volunteer hasn't displaced a paid employee. So again, for those organizations that have both paid individuals and volunteer individuals, you have to be super, super cautious, because you can end up in a pickle. Not to say that you can't have volunteers. You just really have to be cautious when you have folks who get paid for the job, and then when you have folks who are volunteering for the job. All right. So same type of service. And this goes back to the question that just came up. All right. So the law does not, hello? Oh, I thought I heard a question. All right. So the law does not permit an individual to perform hours of volunteer service for a public agency when such hours involve the same type of services that the individual is employed to perform at the same public agency. So what do they mean by that? It means sort of the classification. So if we think about the classification of different types of work, and I think ambulance is like 62301 in the national insurance codes. What we're talking about is if it's the same sort of occupational classification, or if those duties are so closely related to those duties that they perform in their regular employment. So they use some examples, and there's a great little guide that I have in here, and I will send the slides with the hyperlinks, which will be active hyperlinks. I'll send those to Kim so that he can share them with you. But what they get at is this idea of a cross-trained firefighter EMT. The Department of Labor in different advisory opinions have said a cross-trained firefighter EMT, that those duties are so similar that they will consider those to be the same agency. A firefighter slash police officer, or a fire marshal, firefighter, mechanic firefighter. So mechanic firefighter, they said those are not duties that are so similar that such that they would be the same agency. But the firefighter police officer, there are, as I said, case by case, the type of work that a police officer is doing is pretty substantially different than the type of work that a firefighter does. Could one volunteer? Could one be a paid full-time police officer, but then come back as a firefighter, provided that individual, let's say, I know that there are communities that have this. Police officer works full-time, but then at night that police officer is also on the fire department as a call volunteer. If that police officer who's volunteering shows up to a fire call and starts performing law enforcement duties, then you can get yourself into some pretty substantial trouble. And the problem is that there are very rarely that bright line or delineation between activities or duties that might be occurring on the scene. I know it was very common at our fire department when we had law enforcement who also happened to be firefighters. We had a police sergeant who also happened to be a fire lieutenant. And there were times when he was in fire gear out directing traffic. And that starts to get you. Now, in our instance, it wasn't bad because our fire department, despite being call, was paid for that call. So it wasn't really an issue. But where they ran into issues were the issue of overtime, right? So, for example, if that individual was working, had worked 40 hours or 50 hours on the police department and then came in to do fire calls, if you want to be safest, you pay overtime. And I believe, and in fact, in this instance where they were doing some of that, that's in fact what our town did. So it really comes down to what's the type of work that individual is doing and how distinct. And of course, what they say is it is a case-by-case analysis, right? Do they have separate payroll and retirement systems? Are they considered separate entities under state law? Do they have separate budgeting and funding authorities, et cetera? So it's important to understand that this is every single time, every single question that comes up about this, we are going to have to do an individual analysis of whether that person is working for the same agency or whether they are not. This is very rarely will there be any absolutes in this instance. The IFC, or the International Association of Fire Chiefs, has this great little booklet. I have the hyperlink here and it will be included in the slides. Even though the slides come over as PDF, all of the hyperlinks should be active. I'll test them before I share the slides with Kim. But this is about a 10 to 20 page document. In principle, there are some associated resources like copies of the statutes and so forth. But this document does about as good a job as I've ever seen anybody do, or any even lawyer do, on when is someone a volunteer versus when is someone a paid or compensated employee. So strongly recommend that you read it. It is a quick and simple read. I would say that the majority of those 10 pages really do cover the practical applications. And I was going to say, imitation is the most sincere form of flattery. I will tell you that I'm citing them, so I didn't steal it. But what I would say is I used a lot of that presentation. This presentation came out of this booklet. If you are paying volunteers money or anything of value that can be reasonably construed as an exchange for work, you are in a very, very dangerous situation. So in particular, as we talk about those things where you are paying people a per call stipend, or you are paying people certain amounts of money as to quote be on call, you need to be very, very cautious. If anything looks like remuneration for hours, you need to be, or remuneration, I'm saying the word wrong, for hours, you are going to look a lot like, that person's going to look a lot like an employee. So you can do payments. What the law says out is that you may pay a nominal fee to a volunteer. And what do they mean by a nominal fee? Well, things like you can pay certain expenses that person might experience. So for example, if we had individuals who were going out and buying a uniform, or were going out and buying, let's say they had a certain amount of fuel expense to go. Let's say you were in a particularly rural area and they were taking their own vehicles in some instances to calls. Could you reimburse them for that? You can reimburse them for that. What I would strongly suggest is that there be some math behind that or some justification for the amount that you picked. If you were reimbursing them for, let's say, certification or continuing education fees, again, reimbursements are always permitted under the statute, provided you can, to some degree, prove that, in fact, it's a reimbursement. So any expenses you can pay for certain reasonable benefits, and we'll talk about what those are in a minute. But it has to be that nominal fee, right? It's not a substitute for compensation, and it's not tied at all to productivity. So if you have stuff that is tied to productivity, hey, if you meet certain number of calls, we're going to give you this amount of money. You have to be really, really cautious there. What the Department of Labor and the various opinions came out on was a nominal fee is 20% or lower than what a paid individual in that position would look like. So, they can be paid those expenses, those can be paid those benefits, nominal fees. You just want to make sure that you can show that it is if it's an expense reimbursement, that it is a dollar for dollar expense. So somebody didn't pay, let's say they decided to carry their, a personal malpractice insurance for $500 or $200 a year. If it were $200 a year and you reimburse them $500 per year, you're going to get yourself into trouble. If it's $200 per year and you reimburse $200 a year, then you'll be fine. This is the importance about this thing, is making sure that you have a very, very clear policy over what you will and will not reimburse from an expense perspective and what the basis for that reimbursement is. So if what you said is, we had 50 calls last year for which our volunteers were responding in their own vehicles, the average distance to those calls were X number of miles, making a rational calculation based upon current gas prices at X. We're going to reimburse you X number of dollars for mileage. You can do that, but just make sure that you can back that up. All right. Again, it cannot be in exchange for production, right, or productivity. There are two principal advisory opinions that are cited in that IAFC booklet, but and also all of them sort of seem to, all of the advisory opinions that I was able to find really come off of these two. One was done in November of 2005 and was geared towards a high school and coaches. The other was done in 2007. This was the IAFC's effort to try and get clarification from the Department of Labor and the OIG for the Department of Labor on what is permissible and what is not. So the first one was this November of 2005 was an individual who full-time was a custodian for the school, but he volunteered to be a coach for the track and field. Now, it wasn't mandatory. There was a stipend to him of $3,675, and that was really geared at reimbursing him for like pizza, ice cream, other things that he did in an effort to recognize the players as they, sort of in camaraderie and team building exercises. All right. So there was no extra, the school didn't incentivize him. Hey, if you make the playoffs, we'll give you an additional $1,500. It was really just, hey, if you wish to do this, there is a stipend that we will pay you to reimburse you for what we know are expenses associated, right? To encourage the team to, to build teamwork and to build camaraderie, and then really to reward the students who were on the track and field for, working hard and so forth. So what the Department of Labor says in almost every instance as it relates to this issue is we're going to look, as we analyze these situations, we're going to look at the economic realities of the arrangement, right? So if they start to, they're going to look at it from a totality of the circumstances and the economic realities. There have been numerous instances in which they've used the economic realities test. And the idea behind that is when we look at all of the factors does it look like you were trying to pay? Does that person look like, are the economics of the situation really an employer who is trying to pay someone less than minimum wage, or an employer who's trying to avoid essentially paying an overtime stipend? In other words, if what we had from the coach was, well, we're going to guess that to pay a coach to do this would be $5,000. And so, we think it's about 2 hours a week times the 10-week season of track and field. And so when we calculate that out at roughly, $10 an hour or whatever that, right? If that's the basis, you're going to find yourself into a lot of trouble. So what they say is, we're going to step back, take a look at all of the economics of the situation, and we will consider whether in fact that is truly voluntary, whether in fact whether the coach, whether there was any additional incentives or any other monies tied to the performance of the team. Now, in follow-up to that, because the IFC was concerned that that really wasn't very clear, they wanted more information, they sought an advisory opinion that came out in August of 2006. And what they really were trying to get at is, hey, what kind of, what basically can you provide us with some brighter lines about, and these opinions, this other opinion is about a 6-page advisory opinion from the DOL. And what they really get at in this is they wanted to know what constitutes a nominal fee. By the way, the 20% that we talked about earlier, this is where that 20% number came in. So they say, hey, nominal fee, it's fine to cover certain expenses, uniform, dry cleaning, materials, supplies, group insurance. If in fact the agency were providing, let's say, malpractice insurance, if in fact the agency, by the way, one of the things that I really had never considered as I was researching this issue was that if you are carrying workers' compensation insurance, you need to be cautious about that, because I saw a fair amount of language that suggested that workers' compensation insurance is for employees. I've got to do some more digging. And in fact, I'm going to call the United States Department of Labor to try and address some of that. It's entirely possible, by the way, that the only way they'll address that is if I seek a formal advisory opinion, because what all the indications I got were that if an individual was injured in the context of that volunteer activity, that there would not be coverage specifically as an employee, but there might be coverage under some other insurance policy. So admittedly, it's an area that I still need to explore and try and find out more information, because I'm sure nobody who would volunteer to cover a fire department or an EMS agency would want to be financially at risk in the event that they got injured. But again, what it comes back to is, what are the economic realities of the arrangement between the volunteer and the employee? Or I'm sorry, I want to make sure I clarify. They say not an employee. One of this comment, and I don't normally plug in a whole bunch of text into my slides, but I thought this one was important, says, moreover, consistent with the discussion, the factors to be considered, distance traveled, time and effort expended, whether it's around the clock versus limited availability throughout the year or upon request, compensations for per call or other similar bases may be acceptable so long as they may fairly be characterized as tied to the volunteer's sacrifice rather than a productivity-based compensation. All right, so accordingly, nothing in the statutory language would directly preclude the payment of a nominal per call or even shift fee to a volunteer, as long as Section 553106E specifically provides a nominal fee can be paid per call or similar basis. Now, really what we're getting at there again is, and I did some searching, it's not hard to figure out what you would have to pay an EMT or a paramedic per hour. What you need to look at is, if when you do that calculation, the fee that you're paying the volunteer is greater than 20%, you are in very, 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 very difficult waters. So again, now, could you pay a nominal fee plus reimburse for certain expenses? and other things like, let's say I'm reimbursing you for my fire department paid for our recertification fee every year. They paid for certain uniforms every year. They paid for continuing education and some other nominal benefits. But again, they say expenses, some reasonable benefits, nominal fees, and of course, token gifts are perfectly permissible. When we're talking about expenses, what are we talking about? So you can reimburse them for the approximate out-of-pocket expenses that are incurred by that volunteer, right? Which could include things like meals, transportation, uniforms, tuition. So let's say you had a volunteer who was going to go from EMT and wanted to go to paramedic school, and the volunteer agency wanted to fund that paramedic school. I believe you could do that because that's not per se a wage. It's reimbursing them for an expense that they have that will eventually benefit the organization, books, supplies, or other materials. So just so to me, there was, while everyone's very concerned about when do we tip the scales and we're suddenly an employee and we might be violating the Fair Labor Standards Act, I think these are the ones that most people go, that makes sense to me. I think it sounds reasonable to suggest that we are going to reimburse them for those expenses such as these. Now, what they say, reasonable benefits, right? A public employer, just so we're clear, right, does not risk the status of volunteers by providing liability insurance. Now, this workers' compensation insurance, again, I saw a couple of letters that suggested that employees get workers' compensation insurance. What I believe the distinction is here is one being a public employer versus one being a nonprofit employer. So if you are a municipal agency, my understanding of the current, or at least current interpretation of the law, is that a public agency could furnish workers' comp, but that a nonprofit, non-public agency, if they do so, they could be running afoul. Again, I'm going to do more digging. I'm going to check with the Department of Labor on that. My efforts to reach them over the last 2 days have not, normally they're pretty good. They just have not been so successful. So liability insurance, could you provide malpractice insurance for your folks? You certainly could. Could you provide some level of health, life, or disability? If you're a public agency, you certainly could. Pension plans, I would say you need to be pretty cautious about pension plans because, again, generally pension plans look to be a pay for play type activity. Length of service awards are perfectly permitted, and there are a lot of agencies, including my agency, that permit people to volunteer for the fire department, let's say, or to volunteer for a public agency for the purposes of having some tax relief. So we had a guy who used to come in every year, and he would man the burn permit desk in our town, and he would get a relief of a couple $1,000s off of his yearly property taxes. Those are all permissible. Now, again, public employers may pay volunteers and all of that. They've indicated that public safety departments, now remember, there is a distinction between a public safety department and a nonprofit. So as long as they are in fact bona fide, right, that distance traveled, time and effort expended, whether the volunteer has agreed to be available around the clock or only during specific periods of time. So let's say, for example, you have a volunteer who has to stay at the station and they're not free to go do what they want. You need to be cautious. Again, if they're volunteering to cover a shift, okay. But again, recognize, do you have people who you pay for that? And do you have people who are volunteering for that? Just as long as they aren't the same people. Whether that volunteer provides service as needed throughout the year. So there are people, and I think what they're getting at there are, geez, do I volunteer my time during voting, or do I volunteer my time during town meeting? That is sort of episodic, as opposed to those people who start to look more like employees. Now, I don't think anybody, this one I sort of smirked at, like, gift bags, gift certificates, or, you have to be careful with gift certificates too. They have to be a nominal fee, not to go above that 20% of what a paid individual would get paid to do that job. Certain pins or tote bags Truthfully, they can keep the tote bag. I'd rather actually not have the extra friggin' tote bag hanging around the house. It's like a conference bag. Now, other permissible, right? Training, skills development. No doubt that any public agency that's doing EMS or fire or police are going to be training those individuals. So those are permissible. Certainly if they sent you off to a conference like this for the point and you were volunteering, that would be fine. Job recommendations, which is almost foolish, mentorship programs, leadership roles, or other sort of personal feedback. To me, again, there's unquestionably that doesn't seem to be stuff that is, I don't even think there should have to be an advisory opinion on that. Now, per call basis, generally the amount of a nominal fee may not be tied to productivity and may not vary based upon time spent, but the Department of Labor did make a per call basis exception for firefighters. Now, what's not totally clear to me is they didn't have an advisory opinion on standalone EMS agencies, but I think given that there's an advisory opinion that said firefighting and EMT or EMS services are considered to be the same employer, I would suggest that this carries over without any question in my mind. The most recent letter, they said noted that compensation per call or other similar bases may be acceptable so long as they may be characterized as tying to that volunteer sacrifice rather than, again, productivity. How about a monthly stipend? They've stated that you can do a monthly or an annual stipend depending upon how much that stipend is. So recognizing, again, that it cannot be over what 20% of an annual salary for an EMT or a paramedic, or if it were a fire chief or a deputy chief or a lieutenant or one of those other roles, or an education officer, etc. Right? Again, the 20% is as bright a line of test that we're going to get, I think. Hourly rates, stipends, right? They've determined that for firefighters that's okay. What I would suggest is I would stay away from anything even remotely related to hourly stipends, because to me that looks more and more like an hourly wage. Now, a couple of examples that were listed in that booklet, and like I said, if I didn't make it clear, read the booklet. I think it does a very nice job. However, it still leaves a fair number of questions unanswered. So county fire department pays $50,000 to hire a full-time firefighter for 1 year. The fire department pays an annual stipend of $9,500 to a volunteer firefighter to perform those same services. They would constitute this as a reasonable or a permissible stipend to pay that volunteer firefighter because it's under the 20% rule. So that would be permissible, as opposed to this one where the same firefighter $50,000 a year and they try to pay an annual stipend of $15,000, which is over that 20%, and life insurance to that volunteer firefighter. So when we get back to the economic realities, understand that when you get into all of those things that you're paying for that, if it's an expense that the volunteer is actually realized, then you can reimburse them, and that does not calculate into that 20%. But if it's stuff that you are giving them, let's say you gave them $1 million life insurance policy that you paid for, we would have to look at what the cost of that policy was, plus any other per call stipend, to make sure that the total of those dollars did not equal 20% or more. Greater than 20% of what a full-time firefighter or someone who was being paid to do the job would get. So it's important you understand you couldn't just give them a free membership to BJ's, a membership to a Lifetime fitness center, plus a life insurance policy, plus, right, you need to take the economic realities, look at all of the benefits that person receives, not expenses or reimbursements, but all the benefits that person receives. And if it's 20%, if it's greater than 20%, then I believe you are in dangerous territory. So what they say is, again, you need to look at those total payments, right? So whether each specific payment to volunteers qualifies either an expense that they have borne or reasonable benefits plus the nominal fee. So you take all of that together. If the expenses are stuff that they've actually paid out of pocket that are reasonable and tied to them performing their sacrifice, them performing that job, driving to the call, or certain medical supplies, that's fine. You can take that number out. But if in fact you're looking at that and you're paying them twice what that expense is worth, again, you're getting into what would be something that would need to be compensated or would need to be included or calculated within that total compensation piece. Then that nominal fee could not exceed the total compensation paid for the person performing that same or similar services. And what we mean by that too, and certainly shouldn't be as high as what you're paying them, but if in fact it's more than that 20%, you are in dangerous territory. And then analyze that entire package, right, in the context of the economic realities. So I took the liberty of taking a look to say, okay, what does your average EMT make? And I just used Colorado, and I pulled this off of Glassdoor, which is a website. If you've never looked at Glassdoor, you should go on Glassdoor and look up your organization. You may be surprised. It's often where a lot of folks that might work for you might post comments about what it's like to work for you. But Glassdoor also does a ton of stuff like, surveying employers and employees to find out what, compensation and benefits they might have. So what it lists in Colorado, now understand that's probably taking an average of those areas that are urban as well as those areas that are, super rural. So what you would want to do is, to the extent that you can find out what a firefighter EMT or an EMT in your area is making, you would want to multiply that times that 20% to figure out what that total stipend or nominal fee amount could be. So for some of you may go, geez, and I have no idea what the average stipends that might be paid by your departments are. But what I would say is, if you've done that calculation, and in particular, if you're a combination department that has both paid and volunteer, you have the data, the number. If what you're paying your volunteers is greater than 20% of what you're paying your paid firefighters or EMTs, you are in very dangerous territory. Again, as I say to people, my job's not to tell you what to do. My job's to advise you and say, here's what's going to happen, or here's the potential of what might happen if you do that. So proceed with caution, right? And I know this is supposed to be a 90-minute presentation, but I'm on my second to last slide. What I would say is, and I expected that I would get a boatload of questions, and they may be fact specific, and I'm happy to walk through them all. What I will say is, anybody who's going to tell you that they have all the answers is wrong, number one. Number two, it may very well be that I'll say, this is my opinion. And then I will ultimately always say, I'm not licensed to practice law in Colorado. I am admitted in the federal court. I'm admitted in Massachusetts. I'm admitted in Illinois. I probably could get admitted in Colorado. It's probably just an application. I just haven't done so. And I'd probably, unless I had a client there, I wouldn't want to be paying the $1,300 or $1,400 it would take to get admitted. But what I'd say is, you need to be incredibly cautious. So this is the part where, if we're all standing together, I'd look out in the room and say, all right, pitch me your questions. Tell me, and I'm going to kill the screen share just for a minute so I can actually see you guys. Pitch me your questions and ask again. I know we're city employees. Can a dispatcher run as a volunteer firefighter EMT? Both get paid from the city funds. So if I'm going to guess in this instance, the dispatcher is a paid dispatcher during the day or whatever, but when not working in dispatch is a volunteer EMT / firefighter. Are those considered the same thing? I think it would depend on a couple of things. One, where's that dispatch center? Do we rotate? Like many communities, they rotate a full-time firefighter through dispatch on their groups, depending upon how. If this was a standalone county-based, and I see they both get paid by city funds, but some cities have like regional dispatch centers. If it were a regional dispatch center, getting paid by the regional dispatch center to dispatch, but then they were going to their town or their city fire department, I would say that's probably permissible. If it were town-owned dispatch center dispatching just fire, and let's say there were firefighters that might rotate through and do both, I would say a lot less clear and certainly more concerning, not necessarily dispositive, but a lot less clear. And I would be very, very cautious. So I don't know, Josh, if you can provide some additional information on that, I'd be happy to sort of talk through it more. And I see, I don't know, Kim, the screen shows mostly the big pull down projection screen, but any questions from the room or scenarios from the room that you want me to either try and answer, or, and I say try because again, this is an area where there are not a lot of bright lines, or number two, where I can research and get back to folks.
So Josh did add a chat if you want to look.
Oh yeah. Dispatch has their own budget and full-time employees that dispatch for police, fire, and EMS, and the county sheriffs. Fire EMS has their own staff with their own budget. I would say those are separate, and I think that's fine. I think that would be fine if the person were volunteering to go on EMS fire calls. I would say, whereas they really kind of look like separate, I'm going to presume in this instance, if they're dispatching not only fire, police, EMS, and county sheriffs, that they may even, can I ask Josh, does the fire department have any full-time employees, or are they all volunteer? And I'm looking, 7 full-time employees. Okay, so 7 full-time employees, but does the, or do any of those full, I mean, if they're both, I'm guessing that is the city dispatching on behalf of the county as sort of a service to the county, or is this a county-based fire police and then the fire department is a separate city-based?
In this case, the fire department is city-based.
But the dispatch center is county-based.
He'd have to answer that one.
Yeah. If so, what I'll just answer it, in the meantime. If it's county-based, I would suggest no. I'm not. So I'm not sure that I asked the question appropriately. So the dispatch is not county-based. Is that correct? Dispatch is only for the city, fire and EMS, and county sheriffs. Okay. And then the fire department is the city-based fire department. Oh, I see. So in this instance, I would suggest that the type of work performed by a dispatcher could be performed by a person who is not a certified EMT or a paramedic or a firefighter. In fact, could be just an EMD, or could be just a civilian who's not an EMD. I would suggest that those duties or responsibilities are different enough that would be permissible.
All right, Gabe has his hand up.
Okay.
Yes, we're a special district, and my staff likes to volunteer to do PR events, parades, farmers market, that kind of thing. And we don't have the money to pay them overtime for that, so we're allowing them to volunteer and counting volunteer hours to give them like gift cards or something. Are we okay doing that?
Okay, let me just ask. Don't mute yet. So when you say they're covering county events, are they covering them from an EMS firefighter perspective, or are they just there volunteering, assisting with that event, like in a non-public safety?
Non-public safety.
Yeah, then if they're there, let's say, for example, it's a community, I don't know, I mean, a community, even if it were like a open house for the school or whatever, and they were just there assisting, or, it's voting day and they're assisting voting, or they're, they're helping out with the council on aging and whatever, sitting with elderly folks. Those to me are very different, and they can volunteer to do different duties. So let's say they were a paid mechanic for the fire department, but wanted to volunteer to be an EMT after hours. There is an advisory opinion that says that those are distinct enough duties. In other words, their full-time employment as a firefighter, as a mechanic, is really as a mechanic, not a firefighter. Their volunteer as a volunteer firefighter or EMT was deemed to be distinct according to the advisory opinion. So In this instance, if they were volunteering to do other community / civic type duties, like let's say, be the monitor at the polling station, or, hang out at a community center for the elderly, and play bingo, or help with the auction that they're doing, I think that's perfectly fine. And if you're encouraging that, let's say you're saying, hey, we want to be a good steward to the community. We want we want to encourage our folks to be a big brother or big sister. We want to encourage our folks to, to volunteer at the Council on Aging, and, help them do, call the bingo numbers once a week. I think I'm probably generalizing, and I'm going to have a whole bunch of old people pissed off at me. They're like, we don't all play bingo, What I would say is that's okay if you're incentivizing them to volunteer. There's nothing wrong with that. Again, it's just that's really what one consider. There are a lot of organizations that full-time for-profit entities that actually encourage their folks to do things like houses, homes for, houses for humanity, or Big Brothers Big Sisters, walks for, and they in fact incentivize them by saying, hey, you can have paid time off, one day a year to go do, a walkathon or whatever. That's actually an incentive. That's actually compensation for someone who's paid. But those duties are so significantly different than what they're doing. It's really just a good stewardship type thing, if that makes sense.
No, so this.
Sorry.
Sorry about that.
I dealt with the very same exact situation where some of our paid folks wanted to volunteer for community outreach kind of events, and talked with our lawyer about that. The advice I received was that we should be sure that the employee has a very well-written job description, and that the job description clearly details what they're getting paid for, and the things that they're volunteering to do are in no way included in that job description.
That's actually, I'm glad you brought that up. So a lot of times people roll their eyes at me when I start on an HR consulting thing or an employment law thing, and I say, hey, what I want you to do is send me all your policies, an org chart and all of your job descriptions. And people sort of blow off job descriptions, and there are multiple reasons why job descriptions are super important. Number one is the determining or identifying what the essential functions of a job are for the purposes of the Americans with Disabilities Act and other protected or other employment laws. So if what I say is an essential function of the job is that you're able to lift 25 or more pounds, and I have someone who has a temporary disability due to pregnancy, for example, I would need to be able to go through, identify what the essential functions of the job were, so that when I engage that person in the interactive process, as is required under the ADA, we could talk about, well, geez, if I've got someone who, has been restricted from their physician as being able to only lift 10 pounds, well, the essential function of the job is 25 pounds. Can I accommodate that? What would an accommodation be? Well, geez, can I send that another person along to work? That's probably not going to work because it's an undue hardship. Let's say, for example, we had a light duty program, and I just did this discussion with a group down in Missouri last week, where there was a case where AMR got into a lot of trouble because they had a light duty program, but they only provided light duty to those people who were injured on work. And what the law says now, there was a recent decision against, I want to say it was AMR, and I say recent, it's been a couple of years, but they had a person who was pregnant and placed on restriction, not being able to lift more than 25 pounds. And as a result, that person requested light duty. The company said, no, we only give light duty to people who hurt at work. And what the court said was, well, the people who hurt at work have what would be a temporary disability. And or actually not even a temporary disability, they have a work-related condition for which you are providing an accommodation. If you provide it to people who are similarly situated, or in this instance, people who aren't technically disabled, they're just injured, then you absolutely have an obligation to provide or furnish that same accommodation to somebody who has a protected disability under the ADA because of pregnancy. So what I would say is that the first reason why job descriptions are important. You bring up an incredibly important point. The second reason why is making sure that it's very clear, as we talked about same position, same employer. You want to make sure that you've identified what absolutely is within the scope of their employment. So the job, the thing that you pay them for, versus the stuff that is absolutely not within their scope or employment. So to your point about, geez, if I'm a firefighter EMT or I'm an EMT, my job description is going to talk about EMS related job duties. Now, if I want to go over, let's say I wanted to volunteer, and I'm going to really shave it thin here. Let's say I wanted to volunteer at a health fair, at the town health fair, and I'm going there to take blood pressures. I would probably, but that's one, this is why I hate, this is going to sound terrible. I hate lawyers sometimes, right? Because that's why we're in this mess in the first place. But I also love them because that's what gets you out of that mess in the second place. So what I would say is that's one of those ones where you know what they mean, right? You'd want somebody to be able to donate their time to go take blood pressures for people for a good cause. However, blood pressures within the job description is something that you pay them for. If, for example, what they were going to do, though, was, again, call the numbers, or they were going to go walk around the nursing home and keep people company for an hour and just have coffee with them and let them tell war stories, that would be so far outside of their job description that there'd be no question that they were, in fact, that was compensable time for them. So I think, to your point, and I could see them, but the camera's actually a little foggy. I think the job description thing is really, really important, making sure that they're very clearly defined, that it states exactly what is within their job description. And then if in fact you have a policy relative to volunteering, like let's say, hey, as an organization or as a municipal agency, we want to encourage volunteering within the community, be in there very clear. You may not volunteer performing any of the duties that are included in your job description or in your duties at your employment agency. You may volunteer to do things that are outside of that. Let's say, for example, you wanted to help with the PTA fundraiser, so clearly outside of your scope. Now, if there was a PTA or they have the end of the year events that they have school age children do, where they do like a field day. If the PTA said, hey, Scott, I know you're an EMT, any chance you could come and just, provide EMS, just sort of a first responder EMS coverage during this PTA day? Well, that's something totally different. And you'd have to be really super cautious about that. Now, in most communities, you would just send over an on-duty crew that might just sort of base there for the day. So I don't know if that helps any, but I think you're right on the money as it relates to job descriptions.
Back to Gabe Marino. One more question there, sir.
Yes, so we partner with the fire districts to have a QRT program, a quick response team. And as part of that, for the football standbys, we allow the fire district volunteers to do the standby, and we pay the fire districts. Are we liable for that? Because they're not considered our volunteers necessarily.
So let me understand. So members of your fire, you're the fire district, correct?
So no, I'm the ambulance district,
Okay.
and so we allow the fire district, if they've got if they've got volunteers that want to do EMS, we'll cover their medical liability, and we provide them training and medical supplies. But they're not our volunteers; they belong to the fire district.
So, in the fire district and the EMS, the ambulance district are distinct legal entities.
Correct.
Okay, and they're volunteering. And how are you providing, if they're not employees? How are they considered your volunteer?
No.
So they're but your ambulance district is providing them with training and coverage. I mean, insurance coverage.
With training and medical direction, essentially.
Oh, I get you. So if it were me, I would try and separate myself from that. And what I would ask is, my guess is your medical director is probably more than willing to provide medical direction to the fire department, right? Now, the only challenge is, in many instances, the only way that people have permission to provide emergency medical services care is under the direction of a licensed agency, under a doctor and affiliated with a licensed ambulance agency. In the instance, though, of a fire department, those folks, many of those folks are going to be EMTs and paramedics and will be providing first response. If they have EMTs functioning at the EMT level, my presumption is that they also have their own independent medical director. Is that the case?
They do not. We have an IGA with them, and they fall under us for EMS medical stuff.
Okay, so they fall under you but they're not your employee.
Correct.
I have to tell you, if it weren't for the advisory opinion that I was reading over the last day or two, Gabe, I may have Kim share, or I may ask that you email me and we talk a little bit more about that one, because I will tell you there is a direct on point discussion about advisory opinion on the fact that fire EMS were considered to be so akin as to be functionally the same employer. The only thing that I think might save you is that you are legally, technically distinct entities. But the intergovernmental agreement, I may want to chat offline, and then I may even want to call a co-counsel on that. But I'm pretty sure I can get you what I believe is a reasonable answer. It's that one opinion that really said these are functionally the same thing, and I want to make sure I don't steer you wrong on that one. But I think it's a great question. Anybody else have that same sort of situation where you have an IGA and you're sort of sharing resources? Not sharing resources, that's not the right way to put it. You're providing medical direction to other, like, you have I would imagine that there are instances, I talked with a police department, well, an all hazards department in Texas, that every single person on the department is on the 3 police, fire, and EMS are all trained to perform. They're all certified officers, certified firefighters, and certified EMTs or paramedics. So depending upon when they are, if all 3 arrive, if the police arrive before the ambulance, the police transition into paramedic mode. Once the ambulance arrives, they step back and the ambulance takes over. It's a little bit crazy. So Gabe, I'm gonna get your contact information from Kim, and I will circle back around with you. Actually, what I can always do is go back to sharing my screen, and you can just email me. So this is my contact information. I'm going to ask, if you would, that you email me, and I'll chase this one down, because I'm guarantee you're not the only ones doing it. And here's another thing, just real quick. You're not really at risk from the Department of Labor kicking your backside. What you're at risk is an employee who, upon their termination or upon their separation, decides to say, I think I was an employee. In fact, I think those are uncompensated hours. And in many states, payroll or wage claims carry with that, like in Massachusetts, it's mandatory treble damages. So if I owed you, $1,000, it's mandatorily, no questions asked, $3,000 plus attorney's fees. In some states, it's a permissible treble damages, which means the judge or the jury have the right to say, hey, it's, we're gonna, they could do 2,000, they could do 3,000. So it's permissive. So that the issue is not really from a government coming at you, governmental entity coming at you and giving you a hard time. And the Department of Labor will give you the hard time if one of your employees claims that they should be getting compensated for this time. There were several instances that I read where there were cases where there were sort of either misclassifications or failure to compensate the volunteer who was really an employee. So,
okay.
Any questions here in the room?
Got one.
Yes.
So Scott, when you're talking about the job description, position description, whatever you want to call it.
Yep.
Usually on the very bottom line of the duties is other duties as assigned, right? Because you can't think of everything in the world you want an employee and or a volunteer to do. And so if you're encouraging volunteering in other things, other organizations, other activities in the nursing home, the farmer's market, or whatever, how does that play into that sentence
Yep.
on the position description? Maybe a dumb question, but I was just thinking about it when you brought in the position description.
Tim,
Example.
first and foremost, there are no dumb questions, number one. Number two, always ask. Tim and I usually verbally spar at every conference that we're at. And I think one of these days I'm gonna wake up and he's gonna put his hand over my mouth and go, it'll be quick, Scott, just quiet. But Tim, Tim, your question is really important. So on all other duties as assigned, right? So what I would say is if we're encouraging people to volunteer, hey, you don't have to, right? Not coerced, but if you do, we'll give you an extra day of PTO, right? That you have to be cautious. Now, if you look at that in the totality, does that go above that 20%? Number one, but number two, all other duties as assigned means I've told you to do that. Not encouraged, not asked, not even recommended. I've told you you need to volunteer. That all other duties as assigned is an instruction or something I've told you to do in the context of your employment. That's why, and as I look at the job description, those duties, and this is why it's important. If you have people who have let's say they're a fire chief, but they, let's say like at one point I was the director of human resources and revenue cycle for an organization. And what I said was, let's have one job description for each position. And I just happen to hold both of those positions. What I would suggest is, as someone was looking at that job description, they're all going to be EMS related stuff. And then if I say, and all other duties is assigned, if that was something that was completely outside of the scope, like, okay, you have to go pick up trash barrels along curbsides in the community, that would certainly be outside of that. And I don't think whatever. So to your point, I can encourage, it's not coercion. It's just, hey, we have this, where if you want to go volunteer, you certainly can. We'll give you a gift basket or a certificate, or we'll give you a day off a year. That's perfectly fine. It cannot be, hey, I'll encourage you to volunteer going to cover the football game. That's not what we're talking about. I'll encourage you to go build houses for humanity. I'll encourage you to go be a big brother, big sister. I'll encourage you, that's fine. But all other duties assigned is actually being directed by your employer to go do something. So, hey, I need you to go empty the barrel in the station. That's all other duties as assigned. That's not,
those duties then become payable duties, right? If you're assigning them to go pick up trash
yes,
along the highway, they have to be paid.
So here's the thing. If my employer says, Scott, I know you're an EMT, but today I need you to go stand at the polling station in our community, that would be compensable time, right? Because my boss, now I have a choice. I could say, I'm not doing that. And they can say, all right, well, you're fired, right? And I would probably, when I said, hey, I got told I had to go stand at it, that's not in my job description or any of that. You probably win for a wrongful, well, in an at-will state, people can fire you for good reason, bad reason, or no reason. But if essentially what they say is they're only going to terminate you for cause, and you said, well, I'm not going to go do that, and they fire you, they could try and get you for insubordination. But I think you'd have a pretty solid case to say they were asking me to go stand at a polling station. That's not my job. But again, I think it comes down to, what are you being asked to do? And what's the scope, when it comes to the volunteer piece, again, it's the voluntary nature of that, right? Without coercion, that makes that's a necessary leg of that analysis.
Other questions?
Yeah.
Yeah.
Go ahead, Ginger.
So this is kind of related to the volunteering question that Gabe asked.
Yep.
Your examples were volunteering outside of the department. What if a paid person wanted to do something for the department that wasn't necessarily related to their job, like decorating a truck for a parade, or being in a parade, or coming to a conference like this, that's not necessarily related to their job?
Yep.
Can they volunteer to do that?
Like holding the boot, right? Like doing the muscular dystrophy, hold the boot at the corner. So if in that instance, if you were fundraising for the organization And I would say that that's not something that's normally within your job description. It's not. In fact, it is really separate and distinct, right, from the obligation. So if you said, hey, again, I want you to go, take blood pressures at the age council for aging, that one I'd say is problematic. But if you said, hey, anybody interested, like we had a firefighters relief association. We used to fundraise for the Firefighters Relief Association, which technically was a distinct nonprofit, but and we actually had to be careful that we weren't doing the fundraising for the nonprofit at the same time we were doing assigned duties. But I would make sure that those were separate and distinct times, right? Not during working hours, very distinct things that you're not required to go fundraise, right? You're not required to go attend that conference. If I say, hey, you have to be at that conference, then those are duties. But if I say it's up to you, hey, if you want to go, we're more than happy to pay your cost of going, but those hours are on, that's up to you. You don't have to do it. You're starting to tread with one foot on the other side, but I think you're probably okay. But again, this is the part that usually makes people really not like lawyers, or again, I can't, you never know what it's kind of like, this is Forrest Gump. You never know what you're going to get, right? Like I've walked into hearings with employees who have openly admitted to lying about the underlying cause of their claim, and they've still won unemployment, or they've still won the case. But it's Massachusetts. So all bets are off in this state, or the People's Republic of California. That's another one where you just don't know what you're going to get. What I'd say is, the clearer and the cleaner you can make the lines of what they're doing. In other words, if you have a policy about volunteering, make it clear that you are not permitted to volunteer to do anything for which is included in your job description. You may not volunteer to do anything for which you get paid, right? Like be clear, because what's going to happen when you end up in that hearing is they're going to try and wonder, are you trying to get away with something? And if what your documents say are, hey, employee, you may not volunteer, or hey, volunteer, you may not do anything that you get paid to do, right? You can't volunteer to do anything you paid to do. That goes to intent. Now, if what they heard in the hearing was, well, yeah, there's that document, but what Tim told me to do was that, hey, basically, if you know what's good for you, you want to move ahead at this place, you better start stepping up and volunteering. So again, it's really the sort of totality of the circumstances and being real clear in your documentation about, like if you have people, you cannot have someone who works on the ambulance during the day and then comes back and volunteers at night. You can't. Now, could you have someone who works on the ambulance during the day and then volunteer to do ambulance billing at night? I don't know if you have that situation. That would be a stronger possibility than someone who wanted to do the same duties, but for volunteering, if that makes sense. Does that help at all? Because you can look at me and go, hell no, that left me just as dark as I was before. And I'll try and make the distinction if possible.
No, that was good. I hope that you can't see me, but that was good.
Oh, I can see you. Yeah, I can see you. That camera's following. I love this camera. I don't know what's going on with it, but it's.
We have pretty much that situation. Our office administrator is paid to run the office, and after starting a while, or after being there for a while, she wanted to volunteer as an EMT, and we ran it by the lawyers, and the lawyers wrote up a whole agreement that she had to agree to, sign, and it says that when she's an EMT, she's not paid, and when she's working in the office, she is.
And that comes back to, right, because the only, and Tim, I'll get just one sec, the only area that you could end up into trouble, right, is really that comes when the employee goes, no, I should have been paid for those, right? In most instances, Department of Labor's not going to knock on your door for something like this. They're not going to come in and just do a payment audit. They're only going to do an audit upon finding that there's been a complaint. So I think that the important part that you just said is having an agreement that makes it very, very clear what's permissible and what's not, what the expectations are, what the job duties are, and being really, really clear about it. So that's important. Tim?
So another question on volunteer, this is Drift. So we encourage our employees to attend conferences, like the State EMS conference.
Yep.
We don't pay them to attend the state conference because we're not requiring them to, but we're encouraging them to. So I get that. But what we do is if they go to that conference, we pay them for the shifts that they missed while they're going to that conference. So they don't lose. So the benefit is they're improving themselves, they're improving their knowledge by attending these conferences, but we're also paying them for the shifts that they missed in doing it. Is that legal, wrong?
Yeah, it's a good question. So my gut tells me it's probably okay, but this is another one that I'm gonna spend probably half of the night in a beer sitting there digging through trying to find.
You
Try and
should
find-
be here.
Yeah.
You should be here because we could be having
I'll
that
tell you
beer.
what, there's a little part of me, I'm in the middle of a 12 trip run between Labor Day and Christmas. And there's a little part of me that I prefer to present in person because I think, and there's nothing against Zoom, but after doing 64 webinars in 2020, man, it's nothing like being with the group and being able to it's what happens during the coffee break and the beer that I think really make the difference. So, and Tim and I have the best discussions sitting at a bar. Kim, I think you missed out on the one we had last year at EMS World, or was it last year? But I'm hoping I'll see you there next week. But what I'll say is, I think in that instance, that probably is okay. But I've written it down. I am gonna research that one as well, because I want to make sure when you pay someone for missed shifts, to me, I see that as, hey, it's almost akin to if you go to the conference, right? We'll give you paid time off to go to that conference, right? Which is functionally what you've done. So I think that's probably okay. But what we're getting into now is it's sort of a volunteer situation. It's a question of whether it's compensable time because they're a paid employee, right? And
Right.
I think my gut is it's fine. I just I'm gonna dig through, and then worst case scenario, just I used to work at the United States Department of Labor, so there's some knucklehead like me that was on the other end of that phone who had 8 volumes of regulatory language on their thing that they would dig through every time a question came in. So
Because would that fall under that 20% rule again? Because that, when you actually do that.
So interesting. The question would be whether when they went to the conference, whether that was considered to be volunteer time, right? But in fact, is it? Because they're actually compensated while they're gone, right? You're paying their missed time. The question, and then by the way, are any of your people volunteers, Tim? Yes? No. All right. So again, the situation is in this instance, you are, in that regard, I would say them going to the conference is not considered volunteer. In other words, it's not considered volunteer hours. It is considered to be hey, we encourage you to go to the conference. I'm presuming you pay the cost of registration for the conference.
Yes.
Yeah. So in that instance, I think you're fine. Right? Because what you'd have to do is follow the regular Fair Labor Standards Act regarding travel to and from, right? I'm not saying you necessarily have to pay them to travel to and from. If they're traveling during the time that they would normally be working, you actually have to pay them. If they're traveling, let's say you have a Monday through Friday employee and they have to travel Sunday to get to a conference that's going to start Monday at the term, you actually don't have to pay them during that time. But interestingly, if they travel on Monday when they'd normally be working, you do have to pay them. I hate the travel rules because there's if there's 14,000 if thens. So let me just, yeah, Dave, I was just going to grab Dave's question. How do you reconcile the employee saying that you cannot dictate what they do on their own free time, i.e. volunteer as a medic for a scout camp off duty? Yep, that's a good question. So what you can tell them is, right, I have people all the time are like, well, I'm gonna cover my son's pee-wee football game, or I'm gonna cover it because I'm gonna decide to do that on my own. What I remind people is in most states, the only right that an EMT or a paramedic has to provide any paramedic or EMT services are when they are working in conjunction with a licensed ambulance service under the direction of either affiliate or a contracted, a organizational medical director. Anything that they do outside of that is in fact uncovered, and they're only likely covered to the standard of a first responder. So if they did, let's say they were out on scene at a Pee-wee game and they decided to drop an IO into a kid, they're probably in a lot of trouble. And legally, if something went sideways, they would absolutely not be covered by their organizational insurance. And in fact, in my opinion, would be screwed. Now, I see it happen all the time. However, what I'd say is it's because people don't recognize that just because you have a certification on your arm just means that you've passed the certification. It does not mean that you have a right to practice as an EMT or paramedic anywhere you want, anytime you want. Now, that being said, what I'd say to someone is understand if you go off to cover that camp, scout camp as a medic while you're there, because if someone dropped in front of me, I promise you right now, I would do everything I possibly could. But like, let's say, for example, I brought my own little first in bag with intubation kit and all that. I would be off the path and probably not covered by anybody or any kind of insurance. So my suggestion, Dave, in that instance would be say, look, you want to do that stuff? Have at it. Just understand you have absolutely no protection whatsoever from this organization. And you may very well be practicing without any legal authority to do so. And as a result, you could be personally liable for any harm that you caused while doing that. So there's a lot of law right now. New Jersey in particular is getting, New Jersey, California, Illinois, they're getting pretty picky about laws that permit an employer to restrict an employee's off-duty conduct. And in fact, as so far, and I know Colorado is no stranger to the marijuana issue, in New Jersey, you cannot not hire someone because of a positive marijuana test. You cannot fire someone because of a positive marijuana test, not permitted. You can only fire or not hire someone because you can prove that they are currently under the influence of an intoxicating substance. New Jersey is addressing that by creating what they call, in law enforcement world, they have a drug recognition expert, but you can only become a DRE if you are also certified in field sobriety. They're coming up with something called a work impairment recognition expert. So they're going to create essentially what will be the civilian version of a DRE, and I'm gonna probably attend that class and then hopefully be able to provide some instruction for folks outside of those areas. Because really what it comes down to nowadays are, first of all, everybody's high, like 80% of the time. I smell it when I drive down the street. I smell it driving down the street. I smell it in my office hallway this past week. And I said to the guy in the office next to me, I'm like, dude, what's up? It smelled like weed. He's like, yeah, that was me. I'm like, what the hell? I'm like, remind me never to buy any products from you. But what I'll say is a lot of organizations are still testing for marijuana, but they don't test for alcohol. And my sort of advice to employers now are, hey, if you don't test for alcohol, don't test for weed, because truthfully, if we could build homeless shelters as quickly as we built dispensaries in Massachusetts, there'd not be one person living on the street. And we'd name them the cool things like Happy Valley marijuana, cannabis, or whatever. But what I would say is, the volunteer issue, you are going to see more and more regulatory language around restricting what it is, on your ability to restrict what employees do while they're not at work. And so in this instance, I would just tell them, understand if you do this, you're not covered by us, you're not covered by anybody. And by the way, you could very well get sanctioned by your EMS agency. And I don't know what Colorado provides. I'm sure there's maybe some different law relative to what their authority is to practice. But my bet is they are operating under somebody's medical license.
David has a question online. David?
Yeah, so Scott, just to clarify a little bit more on Gabe's thing about our staff volunteering. So our staff in this instance are representing Trinidad Ambulance District at the farmers market doing blood pressures, which you kind of addressed that. So I could see where we would probably be on the wrong side there. But as far as parades and other PR events, my guess is we're probably on the wrong side due to the fact, because ultimately they are representing us. So then we could not have them volunteer. We would have to pay them and compensate them at overtime. Am I correct on that?
Well, let me do this, because here's what I think. Again, I come from a really small community, and on Veterans Day and Memorial Day, we roll every single piece of apparatus out of the barn for the event, and they don't pay us, or they didn't. I think they started paying us at some point. I'll tell you, the farmers market blood pressure thing, my first request there. So it's interesting. I'm sure many of you are familiar with a lot of the Medicare rulings regarding kickback, where there may be something that would otherwise be characterized as kickback, but it inures to the public benefit. So as a result, the OIG says, yeah, we're willing to not really enforce that. It would strike me as asinine, frankly, but there's a reason I don't work for the United States Department of Labor anymore. It's because a lot of what happened there was asinine. And when I left there, like, why are you leaving? I said, I'm going to go back into EMS. And they said, well, why are you really leaving? I said, honestly, I have the worst supervisor in the world. And he's like, well, she's going to get promoted soon. It's like, don't leave because of her, she's getting promoted. I was like, what the hell kind of incentive is that? So you're telling me you're going to reward them? But needless to say, and he was like, then he looked at me and he goes, yeah, you should go. And even though I maybe would have gotten them to, I don't pay off law school for another 10 years. I'll be 63. What I say is they probably would have paid for that, but it still wouldn't have been worth it. Let me look at that, because there's got to be, I didn't see, I'll tell you off the top what my first answer is. If they're doing blood pressures, I would be using on-duty crews and just have them stage from that farmer's market, right? That would just be me. In the instance where someone's volunteering to go in, I guess my question would be is, well, what happens if somebody has a syncopal episode, or somebody, bottoms out, or it turns out their blood pressure is 210 over, 280 over, 190, right? You're going to then, they sort of transition from being a blood pressure person to actually being a first responder. I think it's, let me swing back around, and I know I'll put it back up on the screen again, just so that you can email me this. And only reason, truthfully, I'm asking you to email me is because at 53, my mind is junk. And what I will say is, I think I'll remember, but your email will ensure I don't forget. So, and what I'll do once I get that answer is I will loop everyone back. I'll loop Kim back in so we can share with you guys, because the goal from all of this is that hopefully you leave without having, I'm always going to say to you, check with your own local counsel, right? Why? Because I can't give you legal advice. I'm not admitted in your state as an attorney. So anything I'm giving you is really based off of as a certified HR consultant who happens to be a lawyer. But that being said, I understand. So on the parade issue, though, I would suggest the parade issue. We don't normally, as part of their duties, make people drive down the street with their lights and sirens on, waving at people on the side of the road. I would say, arguably, that probably could be a volunteer activity. The only thing I'd say is, well, what happens if there's an accident while they're rolling? What if they roll over somebody, God forbid, or they rear end the water department truck, right? Like, and they get injured. Would we be covering them as if they were an employee operating the vehicle? Again, what the Department of Labor repeatedly says in every single advisory opinion, well, actually, it's just like they do in the OIG from Medicare. They say, we're only relying on the facts provided to us, and this doesn't necessarily apply to everyone else. That's one thing. The other thing they keep saying, though, as it relates to volunteers, are we're not looking to put so many constraints on volunteers as to such functionally make it so nobody ever wants to volunteer. We recognize the important role that volunteers play in the United States and in, for charitable organizations, civic organizations, et cetera. So they're not looking, what they're really looking to do is avoid situations where people are essentially being sort of encouraged or pushed to do things that they otherwise should be getting paid for. Right, that in fact people are out of the goodness of their own heart, donating their time, and not because they've been leveraged to do it. So and I'll even include that language when I email back to Kim or tomorrow morning or tomorrow when we do our next session on cost collection. But what they really get at is, hey, we're not looking to prevent people from doing what the right thing to do is. We just want to make sure that people who aren't intending to volunteer or who shouldn't be volunteering are not getting paid when they otherwise should be getting paid. So Dave Detrey, I don't know if I'm saying that name correctly, so forgive me if I'm not, but Dave, I see your hand still raised. Do you have another comment?
No, but you did answer my question. You did pronounce my name correct. And Gabe, we're going to add that question to an offline conversation with the QRT stuff. So we'll be in touch. Thank
We
you.
got one other question in the room here.
Yep.
Scott, before we sign off.
No, I'm here until you all kick me off. So whatever you need.
We want to eat, so.
You're like, no, I've had enough of you. So what do you got?
Just to follow up a little bit on the training thing. So many of us will send EMTs to paramedic school or other training, and they go off and they do that. Sometimes it's paid, sometimes not. That's really not my question. My question is that now with some of their field internships and so on, they'll come back and do that with our organization as a third rider and do all of the normal duties that they would do otherwise. But they'd be taking care of patients, writing reports, cleaning the station, doing all those things, truck checks, all those things. But they're really doing that as a student, and it's the reason that they're there, but they're also our employees. Do I need to be paying them?
Yeah. So here's one of those situations where I think being really, really clear in what role they have. So when they're there, this is pretty common. A lot of even paid organizations have, folks who, even private for-profit organizations will have employees who go off to a paramedic program and have to get their ride time in, and they come back to their paid agency to perform that ride time. Now, my presumption is, does the school require that they wear like some designation that says they're a paramedic student? I can see you.
The school requires that they wear the school uniform, not ours.
That's number one, right? So this comes down to that idea of whether someone's an independent contractor or an employee. There was an ambulance service, believe it or not, that tried to suggest that they're basically that their folks using their ambulances were in fact like Uber for ambulance. So they were in their uniform, in their vehicles, and I was like, look, man, if it looks like an employee, smells like an employee, it probably is an employee. In your instance, where you're identifying this is part of an educational program where they have to do their ride time, they are in someone else's uniform. They are doing duties that they otherwise, let me just ask, are they doing things that if you had someone who didn't work for your organization but was riding along, are they doing things that those people would not be permitted to do?
Probably just because they know the job better, they know the station, they know the equipment and the vehicles. They will step up and do things because they want to. But a student from another organization would be more apt to be sitting in a chair someplace studying in between calls.
Yeah. So here's what I'll say. I think the Department of Labor would say, look, it's a recognized program. This is a recognized practice. It would be better if you did have other people doing that, right? And if they are, even better, right? They're in their own uniform. They're not punching in on your clock. Their folks are treating them just like they would. Now, if they choose to, you just have to be careful, because what I say is, if, for example, I walked into a station and Kim was there working, and I said, Kim, I thought you went home 2 hours ago. Your shift ended 2 hours ago. Kim's like, yeah, but I didn't have anything to do tonight, so I just thought I'd hang around and help. And I go, Kim, I hadn't approved that overtime. Kim's like, no, I'm just here on my own time. That's not permitted legally, right? So one of the things that I might suggest to them is just say, listen, this comes down to, again, being really, really clear. Look, when you're here in the capacity as a student, it's really, really, really important that you're not doing the things that you would do when you were an employee. Now, I certainly don't want to necessarily discourage you from helping out, but I want to be clear that you're not here in the capacity as an employee, you're here in the capacity as a student, intern, or ride along. And so it's important you understand that if you start acting like an employee, that could create some problems for us as an organization. So, again, remember, the only time something like this is probably ever going to come up is if the employee makes the complaint and goes to the Department of Labor and says, hey, I'm basically working, but they're not treating me, they're not paying me because I'm this paramedic student. If that happens, you just would have to be able to defend, no, this is a practice that we regularly do. And it's, normal part of the program. We tell our, any of our ride along paramedic students who happen to be employees not to do that. They're not acting in the capacity of an employee. My guess is they're covered under the insurance for the school, not yours. And so in this instance, I think all of those things, right? Separate entity, separate. So I think you're fine. But just, I would probably have at least a statement that says, when you're, in your agreement, if, in your agreement with the school, if those people happen to be employed for us, they understand that this is not working hours, that they are not working for us, that they are to follow the guidelines of the school and any of the guidelines that we've established for students that ride along, not necessarily the guidelines as an employee, if that helps. And I'm happy to look at that agreement. If you wanted help drafting a statement or something along that lines, you could send me the agreement that you have with the organization, or if you wanted to create a statement, I'd be more than happy to look at it and tweak it a little bit. Ultimately, again, I'm always cautious not to get pinged for practicing law in a state that I'm not licensed. I would tell you, send it through your own attorney just to make sure. But anyways, I know it's 5 past. Oh, one more question. What do you got?
Hey, Scott, I got a quick one for you. It's Sean Caffrey. It's nice to see you.
I see you. How you doing?
Yeah, hey, I got a quick one. I think it's super general, but it just leaves me a little bit feeling uncomfortable, and I'm really just hoping that you'll tell me not to be uncomfortable about it. But I have a combination department. We pay stipends. We do all the things. We read the book. We're trying to do it to make the Department of Labor happy. At the same time I'm making the Department of Labor happy, I have to pay that stipend and meet the rules of the U.S. Department of the Treasury and withhold things from it and hand them something that looks like a paycheck. It's for less than 20% and all the rest, but it's got withholding and all the rest. I shouldn't be worried about that, right?
So you said it's because you're using Treasury money?
No, I'm essentially, in order to comply with IRS payroll rules, I'm paying a stipend. I pay my people a monthly stipend who are volunteers.
All right, and
so it's an amount of money and it's got taxes taken out of it.
Yep.
Yeah.
Okay. Yep. Because it's income to them. Yep.
Is there anything about the thing that looks like a paycheck that's problematic in this whole deal?
So no, because here's what I'll say is, if in fact you're hitting that, you're below that 20%. Right, you clear that they are in fact volunteers, that you are providing a stipend, and because it's income to them, right, you are withholding and reporting that income. In reality, they could just as easily report that income themselves, right? You issue what do you issue to them every year?
Hey, get a W-2, yeah, at the end of the year. It just runs with the system. Yeah, because it's in the payroll system. It's just on a separate pay period and it's a tiny amount of money.
That makes me.
It's in the payroll system is to withhold from it.
Yeah, that makes me feel a little funky. I can't describe.
Welcome to my world.
We all feel funky.
That makes me feel funky. Let me, so it's funny, you don't often see, and I looked for this too, is okay, well then how do you pay those people that, those reimbursements or those nominal fees? Let me, Sean, I'm just gonna call it the Sean issue, which, and I will
happy to email you if you'd like.
No, yeah, if you would, but I've got it down. I've got a bunch of them written right underneath my notes here. I will ping all of those, and then what I'll do as I get answers, and by the way, the answer may be, hey, I talked to the Department of Labor, I talked to this, and they gave me that super vanilla ice cream answer that you get. It may be that. Again, I do get a little quirky. W-2s are generally issued to employees. But they're not independent contractors and they're not employees, they're volunteers. Let me just figure out how to best do that. There'll be an answer. So but I may, again.
And I apologize for asking the lawyer the accountant question right before lunch. Thank you.
No. Actually, there's such a fine line, right? And then there are those real psychos that go, not only they get their LLM in tax, so they're lawyers who get their Tim, I'm sorry, we've hit the maximum. But no, I'm kidding.
Let's follow up on Sean's question.
Go ahead.
So when Sean's withholding, is it federal and FICA?
Yeah.
And unemployment and all that nonsense?
Well, there's no unemployment because we're.
No unemployment.
Okay.
Yeah, it's all
But it
digital
is
stuff.
FICA and it is federal.
Yeah, it's really the same problem. Right, the same thing. We get a stipend with the taxes.
Yeah, because I gotta follow the IRS's rules, just like I gotta follow the DOL's rules, and it seems like they conflict some.
So I'm gonna ping the Department of Labor and I'm gonna ping an accountant too. I've got a couple of CPAs that I work with regularly. So I will I'll ping both of them and then we'll put together a little, the after kind of document that I'll send back to Kim. But and then the more detail you can give me in the inquiry, the better, because that helps me understand. But I think, Sean, I've got enough. And actually from everybody so far, I think I have enough. The farmers market issue with the BP parade, I think, that again, I think I've kind of answered, but I want to be real clear to see what they've said about some of the issues, because I guarantee you that they're not intending to prevent people from doing that. And then the paid for shifts that are missed, I still think that's perfectly permissible. The only thing that makes me feel a little weird is when I'm issuing people W-2s, but that is really more an IRS regulation. There are several, the agency I worked for, both IRS and the Department of Labor, had jurisdiction over the ERISA related concerns. They just cover different parts, just like the Department of Labor has part of HIPAA, while HHS has part of HIPAA. So I'll get answers for those. It may take a couple of days, but I'll definitely get answers for those.
Thanks.
Thank you, Scott.
All right, I don't want to be standing in the way of lunch. I'm just glad I'm not.
We could be here all day. This was very good. I appreciate your time.
Yeah.
Oh no, I hope it was worthwhile. It's one of those ones when you said do volunteer, I'm like, yeah, sure. And then I started digging into it. I was like, oh hell, this one stinks. But it is. What I'll say is, I'll always try, and we'll get to the answers one way or the other. So, thanks,
Very
guys.
good.
Hope you have a good. We'll see you tomorrow. Bye.
Bye.